State your appearances, please.
On the record, Tom Ellis, appearing on behalf of the plaintiff.
Your name?
Travis Ackerman.
Thank you, Meltzer.
Thank you. All right. Take time for the adjourned trial date. Are we ready to proceed?
Before you take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Did you at one time enter into a rental agreement with the defendants?
Yes.
I believe the court has a copy of the lease agreement.
I have a copy of the lease agreement that's dated December 27th, 2022.
That is correct. What was the rental agreement for that house?
We rented the house and the attached garage. No, none of the other buildings. And we paid it to be $1,200 a month. And they were, I had.
Right here, we're introduced to the first major fault line in this case. Propane responsibility. The landlord explains that he purchased propane in the summer of 2022 at a cheaper seasonal rate and expected reimbursement from the tenants once they moved in. On the surface, that might sound reasonable, but legally, this raises immediate red flags. The tenants didn't negotiate that purchase, didn't approve it, and crucially, weren't yet parties to the lease when that propane was bought. Notice how the testimony already relies on verbal understandings rather than written terms. The court is going to care far less about what was understood, and far more about what was documented. This moment sets the stage for the judge's later skepticism. If there's no clear paper trail showing what the tenants owed, when they owed it, and how it was calculated, that claim is already on shaky ground.
I purchased the propane and they were to reimburse me for the propane in the tanks. And the tanks will be refilled again in the summer. The cheapest rate is a summer fill. And they would pay for that after they were filled.
And when they moved in at the end of December, did you go out and read the capacity of the tanks at that time?
On the day they moved, well, actually, January 1st, I believe. I think Travis went with me, but I'm not positive on that. Read the tanks, wrote it down, and calculated how many gallons were in each tank.
So, what was your understanding with the defendants as to the propane tanks and the cost of that propane?
We read the gauges on, there's 3 tanks there, 2 1000s and 1 500. We read the gauges, calculated the gallons. The price was set when I bought the propane in summer of 22. The balance, Travis and I read the tank and we calculated it. And I told them they didn't have to pay it immediately, that they would pay it over some period of time, like maybe 300 a month. I'm not sure the number was given. As it turns out, they didn't pay anything on it. Okay. The tanks were filled again in the summer of 23.
So, how much money is owing to you for propane that was used by the defendants?
Now we get the headline number. $1,892 allegedly still owed. But numbers alone don't win cases, explanations do. The judge immediately starts probing how that figure was calculated, how much propane was initially in the tanks, and how much remained when the tenants moved out. This is where math meets law. The presence of over 900 gallons still in the tanks raises a legitimate question. Did the tenants actually consume what they're being charged for? Courts don't assume usage, they require proof. And if the calculations weren't shared with the tenants contemporaneously, that becomes a due process issue. This moment marks the shift from storytelling to scrutiny.
Well, after calculating both what was in the tank and adjusting for what's left in the tanks when they moved out, and giving credit for the 3 payments that his mother and stepfather made, $1,889.02 is still owed.
How much of that is the amount of propane that was in the tank initially?
Initially on the front page, 1,480 gallons were in the tanks when they moved in.
And how much was in tanks when they moved out?
915 gallons was left in the tanks when they moved out.
Yes, you may approach my bench.
Okay.
It's not the way it works here, Council. You asked to approach. This front sheet, sir, when was this created? This handwritten sheet?
Just before our last hearing, roughly 3 weeks ago.
Was there ever an agreement with you and the defendants in regards to reducing the rent if they paid the propane?
Yes, in January, I believe, we had a kind of a one-way heated discussion on the phone, and anyway, long story short, I agreed to a lesser rent, and they were going to move out by May 1st. Contingent on, prior to that, his mother had told me that she would pay, and John would pay the propane bill, and they did pay 500 in December, 500 in January, 500 in February. Then the payment stopped. As far as I'm
Here's where the landlord's strategy starts to collapse. He admits to a rent reduction agreement. Half rent for 4 months, contingent on continued propane payments. But contingency cuts both ways. For such an agreement to be enforceable, its terms must be clear, mutual, and measurable. Instead, we hear phrases like, they'd pay what they could afford. That's not a contract. That's a conversation. Courts don't enforce vibes. They enforce terms. And the judge is clearly struggling to identify how default could be proven when there was no defined obligation in the first place.
concerned, the agreement was void after that because it was contingent on continuing to get the propane tank.
So what was the agreement?
The agreement that I would allow them to pay half rent for 4 months. And they understand they would be out by the 1st of May. That's contingent on, and the mother had already said that she would pay the propane bill. And they did, like I said, they did make 3 payments.
How much were they supposed to make?
They were going to pay what they could afford, 500 or so. It was not an exact amount until it was paid off. The first month they paid 500, December, January they paid 500, February they paid 400.
Until what was paid off?
The complete propane bill.
Did they know what that bill was?
Yes.
How did they know what the bill was?
I'm sure I told them and showed them.
Okay. So
And
what did you show them, I guess, is what I'm trying to figure out.
Well, I don't have the paper in front of me, but it'd be a calculation like you have on the front page of our exhibit of the propane that was there when they moved in. Propane that was there when they.
I get you, but was there a document that you showed them that told them what they should pay?
Can't say for sure. I assume there was. I mean, I'm sure they would have asked for it.
did you know the amount that was owing?
At that time, we did not know what was going to be left in the tanks when they moved out. But the amount that was in there when they moved in and the amount that was added in August or the summer of 23, those totals were there. And there was going to be a correction made, an adjustment.
Okay, but here's my question. How would they know what to pay?
The original bill wasn't paid of approximately only $800.
Okay.
That wasn't paid. So there's at least that much had to be paid. And then the refill in the tank was approximately $1,700 in the summer.
Would you tell them that's never happening again? Okay, so trying to understand this. There's an agreement that they will pay. And their parents are going to help them pay, right?
Yes. Right.
Okay. Part of this agreement is that their rent would be 50%. correct?
Once the pay on the propane kept going.
Well, but part of the agreement is that the rent is 50%. The other part of that is that they will pay the propane. Right?
Yes.
But how do I know that they defaulted on that if I don't know the amount they were to pay?
Mr. Samanek, how much money was owing for propane in January when you talked to them about this?
Okay, so how do they know that?
I believe I showed them and told them. They have copies, or had copies of these invoices.
All right. Here I show you a list of exhibits with our pictures of your house. Do some of those exhibits show the paint job that they did in your house?
Yes,
And you took those pictures?
I did.
And do they accurately reflect the condition of your house?
Yes. These pictures were taken after I believe the day after they moved out.
Okay. I would move for the admission of the exhibits there, the pictures. I believe the defendants have copies of those pictures.
Including the ones that are online for everybody interested in renting a house.
May I approach the bench and give the exhibits of the pictures?
Yes. What exhibit number is this?
Pardon me?
What exhibit numbers?
The exhibit numbers are exhibit 1 through, they're not consecutive numbers. Exhibit 1, 2, 3, 4, 5, 6, 7, 8, 9, and 17.
So 1 through 9 in exhibit 17.
Yes, sir.
All right.
Do those pictures show the walls of various colors at one time?
Picture shows partial paint jobs of several doors and walls that somebody had taken a roller and put a dark blue color or dark color, a couple swipes with probably to test the color several places, and then it was never complete. And another picture shows a room that's painted some color of red that I know I did not approve.
This is where evidentiary rules take center stage. The landlord claims over $1,700 in repainting costs, but admits the work isn't finished, the amount is an estimate, and the painters aren't present to testify. That's a trifecta of evidentiary problems. Courts require receipts, invoices, or testimony. Without them, damage claims become speculative. The judge correctly identifies this as hearsay territory. Just because money might be owed doesn't mean it can be awarded. This moment reinforces a core legal lesson. Claims must be proven, not assumed.
And I did not approve the dark blue color.
Did you repaint that house or those rooms which they put that paint on? Or did you hire somebody to do
The
it?
job is being done, it's not totally done yet.
How much money have you spent on the repainting?
Over $1,700 for paint and labor, and it's not done.
Who's doing the painting?
And neighbor Reese and his wife Sherry Reese.
Is there a bill?
I have an estimate for $1,700, and that's what it is, it's an estimate. I have another estimate,
Where's the estimate?
sorry.
Do you have that estimate with you here?
File.
What provision is plaintiff relying on regarding the painting?
In the complaint?
No, in the lease.
Or damage to the premise?
Sir, was it gonna be painted anyway? I mean, after they moved out, wouldn't you repaint before you rented?
Not necessarily.
Was there difficulty in repainting because of the dark colors?
Yes, it required 3 coats over the,
Did you do the painting?
I did not do it myself.
Well, how is he gonna testify to that, counsel?
Were you present to see what was going on?
I was there every day that they were there. I watched what they were doing. Physically not able to do all that work.
Right, I get that, but are the painters gonna be here testify?
No, Your Honor.
Because all of this is hearsay.
Well, he can testify as the amount of money he's paying to have something done.
Maybe. But he's also saying he's got a contract and the necessity of it being done. They have a right to challenge. I don't have the painters here. I mean, they're the ones telling him that's what needs to be done. Or am I missing something?
He's relying upon his knowledge of what paint looks good and what paint doesn't look good and how he can solve the
I
problem.
don't even know what that means. Somebody is coming in and doing the work. He's talking about what they're doing and the necessity to do that. That's all hearsay, unless I have them here because they're the ones doing it.
I believe, okay, we'll move on then. When they moved in, was there any discussion about the house and the barns and the farmland surrounding that house?
Yes, I told them that I have a farmer that farms the land. He will be going through the driveway, coming in and out. They have irrigation on that farm, and especially in the summer months, he would be in there pretty frequently. My son has and had equipment stored in some of the buildings. And another neighbor has hay stored in some of the buildings, and I have tractors stored in some of the buildings. And I told Travis that what he has is the use of the house and the detached garage, not the other.
Did Travis ever give you a forwarding address of where he was moving?
Not right.
Okay, did he ever give you a forwarding address?
I assumed he moved in with his mother and stepfather.
Not the question. Did he give you a forwarding address?
No.
Go ahead, Ken.
So in summary then, what money is owed to you?
Month's rent.
Of $1,200 per month.
What months are those for?
March and April. $293.66 for the electric bill. $1,889.02 for the propane.
I'm gonna go back to a question that I had that I didn't get an answer to. What lease provision is he relying upon regarding the painting? Is that the one that plaintiff's relying upon, counsel? Paragraph 7.
Talking about paragraph 7 of the lease, which provides.
That's about improvements and alterations to the premises.
Yes.
Normally, that's applicable to fixtures. What provides that to plaintiff? I don't. Well, I'll let you make your argument at some point as to how that's applicable to painting, but go ahead.
Yeah, I have no further questions to this witness.
I like to approach right here. I'm sorry, I've never done this before.
Right there.
Mr. Samanek, are you familiar with section 9 of the lease agreement that we both signed, access to premises? So can you tell me exactly who within, you mentioned that there were multiple parties coming in and out of the private drive. What part of that is within section 9 as being agreed upon?
First of all, it's not a private drive.
Okay, so beside the point, access to premises. It says landlords or their agents shall have free access within reasonable hours to the leased premises for the purpose of examining or exhibiting the premises to prospective buyers or tenants, or for making alterations or repairs. Is there any language that states exactly what you had just specified about farmers coming in with equipment?
Says the landlord has free access.
To make
The landlord.
repairs, alterations, or to show prospective buyers. Were you doing any of that? Were they doing any of that?
For every document,
Hold on, you got one question, let him in.
yes, Your Honor. Yes, Your Honor. For-
My other tenants should have free access also to that main driveway.
So was that written into our lease agreement? That for our awareness?
No, I'm sure you were told about it.
Okay.
You were told that the farmer would be coming through there,
So-
especially in the summertime.
In reference to the lease agreement, what we signed, can you tell me all of the evidence that's been shared about the access to the property, if any of those are within violation or accordance of the lease
I think
agreement?
what you're asking is, those individuals that are coming on and having access to the premises, do they fall within the parameters of paragraph 9? I think that's what you're asking.
That is what we're asking, Your Honor.
I believe they do.
Okay.
How do they do that, sir?
Pardon me?
How does, in your own words, how do their access to the premises fall within paragraph 9?
Okay, first, okay. Access to the premises means the farm. The farm, this rental house is only one piece of the farm. The farmland is a piece, and there's several outbuildings there that are another pieces of the farm. So my people that rent the land from me and rent the barns from me have access through that main driveway.
This exchange is one of the most legally significant moments in the case. The landlord argues that only the house and garage were rented, while the judge repeatedly points back to the lease language, which does not exclude the barns or driveway. This is textbook contract interpretation. Judges don't rule based on what parties meant. They rule on what was written. And here, the lease appears to describe the entire premises without carve-outs. That discrepancy could undermine the landlord's argument that third-party access was permitted. If the lease didn't exclude those areas, the tenant's claim of disrupted quiet enjoyment suddenly gains serious traction.
Do not have access to his house or that short driveway that goes from the main driveway to his house. That's the only part that's private for them, is that short driveway, about 50 foot long, from the main driveway up to this one-car garage. That's the part that Travis did not seem to understand.
Well, hold on. So what's the address there? What did they rent according to the lease?
The house,
No, look at the lease. I get your interpretation, and you may have an interpretation of what they rented, but what did they rent according to paragraph 1? That includes that driveway. Right?
Do the barns have a different address, Mr. Stanton?
Oh, ma'am, hold on. That includes that driveway, right?
if they have access to the driveway to the house, yes.
Okay, but that's the lease premises.
Barns are also part of the farm.
Well, that may be your other problem. Because under terms of paragraph 1, they leased that entire premises. Didn't they?
The understanding was at the time when we talked about it, is they lease the house and attached garage, that's it.
Paragraph 1, I understand what you're saying is the understanding. But paragraph 1 says precisely that they are renting the. Does anywhere in there say anything about the lease premises or about the house? Or let me put it another way. Does anything in the leasing agreement exclude anything on that property?
Doesn't specifically exclude it, it doesn't specifically include.
No. That can be your interpretation of it, sir. You'll answer my question because the lease premises is that address, right? it doesn't exclude anything on that property. So it doesn't say, for example, that address with the exception of the barn. It doesn't say that, does it?
Doesn't say it accepts it.
Is there any other writing that excludes any, that's signed by both parties, that excludes any part of that property? Go on to your next question.
Your Honor, may I submit some evidence for the painting?
Okay, what do you have?
We have a listing that they had made to rent the house out, and all of the photos show the existing paint, showing that no painting has been done as of March,
It was-
May 23rd,
Yeah, the last update was May 23rd.
with no update of photos.
In the same.
But it shows the existing paint in the exhibits that they submitted to you.
This is the judge drawing a hard line. Once hearsay is raised, everything changes. Without the painters present, without paid invoices, without direct evidence, the court is signaling that these damages may not survive scrutiny at all. It's also a warning shot. Litigation requires preparation. Good intentions and verbal arrangements won't carry the day. This ruling strips emotional weight from the painting issue and reframes it as a legal deficiency, not a moral one.
Have you seen that, counsel?
No, I haven't. Today she has pictures, but
You have a copy. Let's provide it to you in the middle folder.
Do you have them?
Yes, he
Well-
does.
Do you have any objection to those photos?
I would object to, Your Honor, in that is something off the internet in May.
How-
If they're supposed to be cross-examining this witness, why don't we ask him when they started the painting? Who put that on the internet?
His associate Melissa.
Well, hold on a moment. Hold on. Counsel, I gave you great leeway in terms of your questions that elicited hearsay. And now you want me to do that with them.
I guess we can accept.
Because, hold it. Because, counsel, if you want to play it that way, we can play it that way. Because here's the deal. Anything regarding that painting, they don't need to provide anything to you. Because all of that is hearsay. The bill is hearsay. All of that's hearsay, because I don't have anybody here. So if that's the way we want to do it, I'll strike all of that. I'll deny that being admitted. How do you want to do this, counsel?
You can have their pictures admitted as evidence, Your Honor. And
That's what I thought. Did you have questions regarding that too?
I have no questions for that. Just wanted to state that it has not been done.
Got it. Well, let me follow up with that line of questioning. Sir, has the painting has not been completed? Has it been started?
Yes.
When did it start?
I don't have the exact date, about 2 weeks, 3 weeks ago.
So is the house currently being rented?
Your Honor, can I ask a question?
In a moment. Did you have any other questions of this witness?
Yes, sir. Yes.
Go ahead.
I would also like to touch on the section 5 of the lease with paying the utilities. Mr. Samanak, it says that we must pay the propane no later than the 31st of December of the year the propane was purchased. Mr. Samanak, when did we move into this premises?
I don't know the exact date. You signed it on the 27th of December.
So it says that our lease agreement starts January.
This is arguably the strongest defense moment. Section 5 of the lease appears to limit tenant responsibility to propane purchased during the lease year. If that interpretation holds, propane purchased in 2022, before the tenancy began, may not be collectible at all. This is where contracts become decisive. The defense isn't denying propane use, they're denying legal obligation. And the judge's questions suggest she's taking that argument seriously.
1st of 2023. And when was the first propane purchase for that house that you're claiming?
propane that was in the tanks when you moved there?
Mhm.
Purchased in the summer of 22.
Okay, so according to section 5, where in that language does that state that we owe that propane if we did not move into the 2023? Within the lease,
Well,
what does
hold
that
on.
state?
Hold on. Her question is, where in that provision, sir, does it say that?
The only place it talks about propane is in section 5.
Okay, so the question then is, where does it state that they would be liable for what is in the tank before then?
Doesn't say it in the lease, it's what they agreed to before they signed the lease.
Sir, if you look at paragraph 5, right? The only propane that they would need to pay would be that which was purchased in the summer of 2023. Isn't that correct? That was a question.
They agreed to.
Sir, listen closely to my question. When I'm looking at paragraph 5, that paragraph basically says the only propane they need to pay for is the propane that would have been purchased in the summer of 2023. Isn't that what that says? Go on to your next question.
And Mr. Samanak, I wanted to reference the conversation we had in January regarding the reduction of rent. Was the stipulation not that we were going to read the meters and then pay the propane appropriately once we moved out on May 1st?
I don't remember you saying that you would pay them.
We agreed that we would read the propane meters and that we would figure out how much that we owed at the end of our lease. And were we given that opportunity?
Remember that conversation, although we did talk about reading the meters when you moved out
Mhm.
and giving you credit for what was in the tanks.
Okay, and so with that being said, they paid up until February when we asked to have the readers met, and then we read, and then we'll pay you appropriately because we did not know the amount that we owed. It was not clear due to all the handwritten letters we've gotten.
Got a question? Do a question. I don't need a statement.
Okay. How would we know what we owe?
This is the judge's central concern distilled into one question. When did they know what they owed? If the answer is after court papers were filed, that's a problem. Courts expect parties to communicate obligations clearly before suing over them. The landlord's inability to provide a clear date or document severely weakens the default argument. You can't penalize someone for failing to meet an obligation they were never clearly informed of.
If we had not read the meters yet.
At that point, you owned almost 100% of the bill, so there's a lot of it could have been paid.
According to section 5, we did not owe 100% of the bill. So how would we know how much we owed until we read the meters at the end of our lease?
You had to go by the numbers I gave you.
Mm-hmm. Correct.
And do you have a date when you would have given us those specific numbers? I know you referenced that there was a document. We don't have a document. So could you provide us with a date in January you would have done that?
I believe I gave you a copy of the bill. The propane was delivered in the summer of 23.
And then we obviously have made a $1,400 payment towards that, which you've admitted. So we have been paying on that. So when have we defaulted on paying the propane?
Now the bill's not paid yet.
Okay, we're in court. So,
Again,
You gave us that for a month and a half, 2 months, and you haven't paid a nickel since.
But when did somebody give them a number?
when we made it.
I mean, outside of being here, when did they have a number?
Gave them a number.
we were served with court documents before we even moved out. stating that we owed that much money.
You gave them a number when they moved out.
Shortly after.
Where is the writing where you gave them the number they needed to pay?
It was in the original complaint.
Ma'am, not it wasn't directed at the defendant. When did you give them a number? Sir,
I have the exact date in front of me.
did you give them a number in writing?
Probably at our first court hearing. After a very heated one-way conversation with Travis, he said he'll never pay another dime.
Okay.
Mr. Salmon, can I ask what time frame that conversation took place in? Was that the call we had in April after we had already satisfied all payments made to you?
Sorry, it's all that.
So can you reference the time frame that call was made in? Was it in April after we had already made all prorated rent satisfied propane payments to you?
Hold on, folks. What was the propane bill that was paid in, that you purchased in 2023?
Copy of it in the paperwork, there was approximately $1,700.
Okay. And they paid 1,500, right? Or their parents paid
1,400. 1,400, sir.
14. Right?
Mom and dad paid $1,400.
Okay. So
This recalculation is devastating. By the judge's math, the tenants may owe as little as $300, not nearly $2,000. This moment reframes the entire dispute. Suddenly, what looked like a major debt becomes a minor balance, raising questions about proportionality and reasonableness. It also highlights the importance of judicial intervention. Without it, unclear math can spiral into inflated claims.
at most, then when I'm looking at the language of this contract, by December of 2023, they owe $300.
$1,400, paid $500 in December, $500 in January.
I don't care when it was paid. Here's the problem that I'm having. The lease itself indicates that the only propane that they need to pay for is that which is purchased that year. So the $1,700 purchase in 2023 needed to be paid by, according to this, by December of 2023, they needed to pay whatever that bill was. Right?
In the end, this case wasn't about whether propane was used or paint was applied. It was about whether legal responsibility was proven. The judge methodically dismantled vague claims, questioned undocumented calculations, and enforced the lease as written, not as remembered. The takeaway is simple but critical. If you want to collect money in court, you must clearly define the obligation, communicate it in writing, and support it with evidence. Cases like this highlight why contracts matter, and why courts exist to cut through confusion. Backhand index pointing down. Now we want to hear from you. Who do you think handled this better? The landlord or the tenants? Backhand index pointing right. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.